Good evening to the students of SLW 646. Karibu sana to my blended mode of class. You are welcome to my class. And anyone can unmute and read what I posted on the screen so that you are with me and I am with you. Both are sailing the same boat to reach to the destination. Yes, in my last class, I dealt up with these three asterisk marks which I put over there. It says about how the judicial, institutional, diplomatic way of resolving the international dispute in the peaceful means that we are discussing. And we covered up to this extent. Now, from here onwards, from there I will continue my class. Means it is a continuation from my last class. Let us see that when the parties to a dispute reach the point of not being able to solve it by negotiation, when the two parties, those who agree together on the dispute, the dispute reach the point of not being able to resolve. Means they could not be in a position to resolve it by negotiations, or the point where they have broken off diplomatic relations, but they are convinced that a settlement is important to them. The utilization of the technique of good office may be helpful. Now the importance of the good office, when it is helpful, it is clearly shown here. The importance of the good office would be helpful at that instance when the parties to a dispute could not able to resolve it by a negotiation, or the point where they have broken off the diplomatic way also relations, but they are convinced that settlement is more important factor. At that instance, the only resort is good office. Is it clear? Participants say, is it clear? Because you have to say, then only I can proceed it. So good offices may be utilized only with the agreement or the consent of both the disputants. So when you agree to the good offices, negotiation flows, diplomatic methods will be curtailed, and they want to settle the disputes, the only resort is good office. The good office may be utilized only with the agreement or the consent of both the disputants. Yes, the good offices may be come into interference at that instance only where the two disputants agree to the good office. A third party attempts to bring the dispute together in order to make it possible for them to find an appropriate settlement to their differences through their negotiation. So a third party will come into the picture to resolve the issue between the two disputants when negotiation fails, other diplomatic way of settlement is finished, or exhausted, then good office comes to the rescue. In this regard, the functions of the third party is to act as a go between the transmitting messages and suggestions in an effort to create or restore a suitable atmosphere for the parties to agree to negotiate or resume negotiation. So, what is the importance of the good office? When the good office will come into the existence? Just now I explained. Raymond, you came and you disappeared, again you came. I will repeat it. Good office come at that instance only when they fail to resolve by the negotiation, and when they fail in the diplomatic relations of the resolving the disputes, but they want to settle the disputes by any means, and hence at that instance good office comes to the rescue. Is it clear? Raymond,
Yes, Professor.
a third party
It's clear,
coming to
Professor. Can
a
you hear me?
third party come to the rescue of the two disputants when the two disputants agrees to the third party and the third party is the good office. So in this regard, the function of the third party is means good office is to act as a go between and transmitting messages and suggestions in an effort to create or restore a suitable atmosphere for the parties to agree to negotiate or resume negotiation. Now I will ask one question because this is nothing but a repetition. What I am dealing today. We already discussed it earlier. But now the question
Yes, Professor.
is, I would like to ask you, the two disputants agreed for the good office. Agreed? Okay. Where this good office would be there? Is it in the state where one of the party is there? Or is it good office in the state another party is there? Or the good office in the state where it is a third nation?
The third nation.
A third nation should be there. And these two parties comes to that nation for negotiation. The representatives, I mean to say, those who are competent to negotiate and argue and represent the state. So, the good office is in another state, and that good office will facilitate these two disputants, Karibusana in the good office, and they try to resolve their disputes in an amicable manner. So, good office plays an important role like empire. Umpire
Yes, Professor.
spelling, umpire spelling,
EMP.
I did not see empire, I say umpire. In the games, there is a umpire. Spelling UMPIR. Okay, your voice is breaking, but I give the answer. When the negotiations start, the function of a good office comes to an end. See, when the negotiation starts, the functions of the good office come to an end. The procedure for good offices, in contrast to the mediation, has a limited function which is simply bringing the disputants together, and the good office make the point. They make the arrangement for the two parties to meet at one platform in the good office. Where the two disputants, parties, negotiation starts, the function of the good office comes to an end. The good office function will not take part in it. They only want to bring them on one platform. The procedure of good offices, in contrast to mediation, has a limited function which is simply bringing the disputants together on one platform. Is it clear? Say yes or no. Your voice is not audible. Speak loudly. Kama Simba, like me. Amna Paka. Be close to the system, then speak. So in mediation,
Yes, sir.
the mediator takes an active part in the negotiations between the disputants and may even suggest terms of settlement to the disputants.
Sir.
Okay. That's why I told you, you sit in such a place where The signals are strong so that you could hear my voice, and when you speak, I could hear your voice also. And use the bundle at least 2000 or 1000. No, your voice is still breaking. Your voice is still breaking. Okay, now methods of good offices consist of various kinds of action aiming to encourage the negotiations between the parties to a dispute. There may be a good offices of various kinds, and also it, in contrast to the case of mediation or conciliation, the preferred of good offices does not meet with the disputant jointly but separately with each of them. These good offices will meet one party at one time, another party another time, and the good office will they will convince to the two parties to come unto their office, and where this good office is there in another country. Seldom, if ever, the preferred attends joint meeting between the parties to a dispute. Normally, the role of the preferred of a good office who preferred terminates when the parties agree to the negotiation. Who proposed or preferred the good offices when they brought together in one platform. When the disputant start negotiation with the another party, then the role of the good office comes to an end, or to resume negotiation. If once the negotiation is resumed, good office role is closed. However, the preferred may be invited by the parties to be present during the negotiation. Raymond, you are asking the question, but I could not understand it. Can you send the message, SMS it, so that I could understand it? There is a SMS facility also there. Did you see the SMS facility? There is a SMS. Suppose if your voice is not clear, and then send the text message. See, I made the message.
Okay, Professor. Yes, Professor.
Now I could hear your voice. So, you have to participate in the class. Otherwise, it's a one-way traffic. It's a one-way love. A love should be from both the ways. Amna chunabuzi in love. Did you get my point? So, it should be from both the sides. And the preferred of good office, here what is pro offered, here PRO pro or offered, who is only one. A good office does not meet with the disputant jointly but subsequently, separately with each of them. Yes, they try to convince means both are at the same place, there will be the quarrel. So, good office meet one time one party, then convince him, then goes to the another country and meet the another party and convince him, and both will be brought into the platform in the other country where this good office is situated. Seldom, if ever, the prophet attend the joint meeting between the parties to a dispute. So, good office never attend the joint meeting. Normally, the role of the preferred of the good office or offered the good office or the good office people terminates when the parties agree to negotiate or resume negotiation. So, in the case of the mediation, an offer of a good office may be rejected by either or both the parties to a dispute. When, in the case of mediation, Naturally, when the party doesn't agree to that one, at that time good office should be needed. When the party doesn't involve to settle their own dispute, then the other person interference should be there. If they want to settle amicably with themselves, at that instant they will choose the good office. So that is the whole idea behind it. So the use of the mediation, conciliation, and good offices has a long history. These methods have been the subject of many bilateral and multilateral treaties. Of course, charter is there, but charter makes its own regulations, and by that, the dispute will be settled those who are members of the charter. However, with the establishment of the League of Nations, before the UN one, there was the League of Nations. Permanent organs were set up to perform the function of these method of pacific settlement of the dispute. So, in this context, Charter of the United Nations list in Article 33(1) and mediation and conciliation emerged, and the jurisdiction also there, but not the good offices is there in the Article 33 Clause 1, and methods of the pacific settlement available to the parties to any dispute. So in our last class we have seen 3 articles. What are they? Article 33, if I not be mistaken, Article 36, and the last one is Article 60. Am I right? Please check these articles in the exam. At least you can write Article 33, Article 36, Article 60 of the UN Charter. So notably in the practice of United Nations, yes, and I heard you. The terms mediation, conciliation, and good offices have been used with a considerable looseness, flexibility, and little regard to the distinction which exists between them. So these are all flexible way of dealing the things, resolve the issues, without any coercion, without any compulsion, without any sovereign encroachment. So mediation and conciliation have both advantage and disadvantage as compared to other method of dispute settlement. They are more flexible than the arbitration or judicial settlement. It is an obvious factor, we have already seen it. They leave more room for the wishes of the disputants and the initiative of the third parties. Yes, they are more flexible. If they did not resolve the issue only, then good office come to the rescue. The disputants remain in the control of the outcome. Their proceedings can be conducted in secret. If they want to make it out, yes, let it be conducted in the secret so that other interference should not be there. However, there are disadvantages to mediation and conciliation. If you see any act or rule, there is a plus points, there is a negative points. And the proceedings can't be started and be effective without the consent or cooperation and goodwill of the disputants. These disputes will come to an end at that instance only when there would be a cooperation and the consent and the goodwill of the disputants. Then only the disputes will be resolved and the conflict would be come aside. The proposed settlement is no more than a recommendation with any binding force upon the disputants. They will recommend it. Yes, you do like this, but it is not a binding force. If they agreed in writing that whatever the decision would be taken, we will bind it. Yes, at that time they do. But when there is no consensus, at that instance, it's not the binding effect or the disputants. So section 2 says, another part, adjudicative method of dispute settlement. And just before we saw the diplomatic way of the dispute settlements, now we'll say the adjudicative method of the dispute settlement. Who will adjudicate? Raymond. Who will adjudicate?
The court,
Either the court or the tribunal.
Professor.
The major disadvantage of the diplomatic method of dispute settlement,
It is
what
the
we
law
just now studied.
of
Yes,
the court.
speak.
Yes, Professor.
Shall I proceed? Shall I proceed? Say yes.
Yes.
Okay. Just now we studied the diplomatic method of dispute settlement. And now, Raymond, your voice is not clear. You are speaking, but I could not understand. You can send the message to me. I can see the message. What do you want to get from me? The message is there. You can send me if you want to ask anything, because your voice is not clear to me today. Shall I proceed? Say yes. Okay. Earlier, just before we saw all the diplomatic methods of dispute settlement, and the parties to them are under no legal obligation to accept the proposal of the settlement suggested to them. In the all diplomatic methods, those are said to be the non-legal methods. When the non-legal methods will fail over there, then the legal method will start. A legal style will start. And that is called the adjudicative method of the dispute settlement. The adjudicative method of dispute settlement are preferably because they provide the issuance of the binding directions. The binding decisions are there because the decision come from the court and the award come from the tribunals. And hence, they have the binding effect. And as the adjudicative method of the dispute settlement are preferably because they are the provide the binding effect on the decisions rather than the mere recommendations in cases of diplomatic methods. In the diplomatic methods, only the suggestions and recommendations. But in the adjudicative method of the dispute settlement is a command, like a sovereign. And it is a binding effect on the parties. It is this binding force of the decisions rendered at the end of the adjudicative methods that distinguishes these methods from other methods of dispute settlement. The earlier methods are said to be the diplomatic method of dispute settlement, which are not the binding factors, but the adjudicative method of the are binding because it is the adjudication of the court and the tribunals. So, adjudicating method of the dispute settlement consisting of the two types of the procedures. What are they? Procedures, arbitration and judicial settlements. How they are? Arbitration and judicial settlements are two methods involve the determination of the difference between the states through a legal decision of the tribunals. Either the tribunals may give the decision or the court give the decision. Whereas in the case of judicial settlement, the decision is made by an established court, permanent, such as the International Court of Justice, or ad hoc. In case of arbitration, it is made by the single arbitrator or the arbitration tribunal, and which is made by any bilateral or multilateral, including the charters, protocols, and declarations. The major characteristic of these two methods is that judicial decision of an award is binding on the parties and must be carried out in a good faith. Either it is an arbitral award or it is a court decision, both are the binding factors. Is it clear, Raymond?
Yes, Professor.
Very good, very good, very good. So it is not until the establishment of the League of Nations and that the term arbitration and judicial settlement became a distinguished. And the covenant of the League of Judicial Settlement meant settlement by the Permanent Court of Justice. Later on, it became the International Court of Justice, where the arbitration means settlement of other tribunals. And this same arbitration, the same distinction is carried over by the Charter of the United Nations. But with the International Court of Justice ICJ, which is there in The Hague, Netherlands, substituting for the Permanent Court of International Justice PCIJ. So at the time the Permanent Court of International Justice was there, at the time of the League of Nations, but once the World War I is over, II is over, then the United Nations Charter has come into the existence, then the Permanent Court of International Justice is changed to the International Court of Justice. Arbitration is considered the most effective and equitable means of dispute, and this arbitration, the parties will agree to the tribunals in the contract itself, and the application of law also they will keep it very much clear when the case of dispute is concerned. So it combines the elements of both the diplomatic and judicial procedures, which arbitral awards or arbitration. It's a combination of both the diplomatic methods and the judicial. In other way, it's a quasi-judicial in nature, but they are the binding factors. They are the bindings. However, it is much more flexible than the judicial settlement. A bit arbitration award is a much more, a little extent flexible than the judicial settlement. A judicial settlement, there is no hard and fast thing. It should be followed, applied, and utilized, undergo. Otherwise, there would be a sanction, and mechanism is there to punish the defaulters or the person who violates such a order of the court in the form of a contempt of court also. So arbitration is a flexible one and a means of dispute settlement. It combines the element of both the diplomatic way and judicial procedure. However, it is much flexible than the judicial settlement. Judicial settlement is a command of the state, and hence people will fear it. It gives the parties to a dispute the choice to appoint the arbitrator, of course, if they want to resolve it, to designate the seat of the tribunal. Yes, if the arbitrator is there and they will approach to the tribunal, both the parties, and they agree to the terms and conditions of the tribunal, yes, that is a binding factor to them. And to specify the procedure to be followed and the law to be applied by the tribunal, it will be decided by the party itself. If there is no party decided itself which applicable law would be there, then the principles of the private international law could be utilized, like connecting factors, theories, and many other aids would be there that will decide it which country law should be applied when the parties did not choose the applicable law. So the arbitration cannot be initiated without the agreement of the parties to a dispute. So arbitration will come to start at that instance only when the party initiate the proceedings or make forward. An agreement of the arbitration may be concluded for settling a particular dispute or the series of disputes that have been arisen between the parties. It may be in the form of a general treaty of arbitration. If there are disputes would be there, if it is settled or going to be settled, but it is the form of the general treaty of arbitration, they will come under it. The usual pattern in the arbitration agreements as regards the appointment of the arbitrator is that each of the two parties have to appoint one arbitrator or more, and the appointed arbitrator have to appoint the arbitrator who is known as an umpire. Now the question comes, how many arbitrators could be appointed over there? Generally, a party, each one should be appointed over there an arbitrator and who is known as an umpire. Because each one, there will be the two, but one among them is umpire and he decides it, what is what. Usually, the arbitratory tribunal consists of the three arbitrators who can decide the majority vote. Always such a thing would be there. It is not the even number, it is the odd number. 3, 5, 7, 9. Those should be the members of the either the tribunal or the permanent judicial body, which is nothing but a court. So the parties may agree to refer their dispute to a single arbitrator, and who may be a foreign head of the state or a government or a distinguished individual. Yes, but he should be not belong to the any one of the party and where they hail from. He should be from the third country or third state and unbiased and selected by both the disputants to listen to him. So judicial settlement is a settlement. Just before that, we see the arbitrators and how the arbitration award would be there, how many arbitrators should be appointed, whether it should be an even number or a odd number, then the decisions will be given. From this, sometimes it goes to the Court of Appeal or the Supreme Court if anybody is not happy by the decision of the tribunal. Because tribunal having the same equivalent like a high court. But in certain places, tribunal is less than the high court demand. Later on, they will go to the high court. After that, they will go to the Court of Appeal. But in the case of Tanzania, if the tribunal has given an award, then one can approach the High Court and later on they can approach the Court of Appeal. Like a Dawson case law, you would have seen. Tedesco case law. Participants, Raymond, are you there to hear the class? Answer say yes.
Yes.
Very good, very good, very good. So, Dawson case law, the arbitration award is given by the UK because both the parties agreed, and this electricity board, they filed a case in the High Court, but High Court say that when you agree together in the agreement, in the contract, now we cannot interfere it because whatever the decision given by the tribunal is correct, there is no impartiality, they follow the procedure which is supposed to be followed. If they are not happy by it, the High Court decision, then Tedesco approached the Supreme Court, Court of Appeal, then the Court of Appeal is upheld the decision of the High Court. Is it clear? Say
Yes,
yes.
Professor.
Yes, now judicial settlement is the settlement of the dispute between the states by an international tribunal in accordance with the rules of the international law. The international character of the tribunal is in both its organization and its jurisdiction. International tribunal include the permanent tribunals and such as the International Court of Justice, yes, and the International Tribunal for the Law of the Sea, it laws, and the European Court of Justice, the European Court of the Human Rights, and later the American Court of Human Rights, and include the ad hoc tribunals such as the United Nations Tribunal in Libya. So these are all though it is like a adjudicating bodies, but their decision also binding factor. So the tribunals include the permanent tribunals such as the International Court of Justice. Of course, it's now a court. The International Tribunal for the Law of the Sea is the tribunal. When the admiralty jurisdiction is there, sea cases are there, it will be handled. And the European Court of Justice for the human right violation or any other factor is there, and the Human Court of Justice will come into the picture. Then the European Court of Human Rights also there, and the Inter-American Court of Human Rights, and the ad hoc tribunals also there, and we do have the human right violation, people's human rights in the Arusha. In the case of any human right violations are there. So these are all having the same effect, binding effect on the parties. If they don't agree to it, then the economic sanction, diplomatic sanction would be by the UN Secretary General. So the ICJ is the most important institutional tribunal because it's both prestige and jurisdiction. The ICJ having at The Hague. It is the principal judicial organ of the United Nations. All members of the United Nations are the ipso facto parties to the state of this court. Who are the members of the UNO? They are the members of the ICJ because ICJ is the one of the permanent organ of the UNO. It is only one organ which is in other country, but the rest of the all the organs in
The Hague, Netherlands.
only ICJ is in Netherlands, The Hague, but other organs are there in
United States.
yes. I know it is the United States, but in which state? Among the 28 or 28 states or 30 states? No. New
New
York.
York State.
It is in New York. Is it clear? Okay.
Yes,
So,
Professor.
okay, the judges of the ICJ are appointed by the United Nations, not by the parties to a dispute. The ICJ has to apply the rules and principles of international law, which are enumerated under Article 38 of the Statute of the Courts. The parties have no choice to specifying the rules to be applied by the court. But in the tribunals, they do agree together, the parties. And hence, that would no, I unmuted. Okay, the voice may be not clear to you, but sometimes when the signals are not there, you could not hear me. Yes, now you could hear me because at the time the signals are not there, that's why you could not hear it. And I also got the indication that my voice is not reaching to the participants. Now my voice is reaching to the participants. So here what they said is
Yes.
the tribunals of the law. Yes, we are here. The ICJ is the most international tribunal because of its both prestigious and jurisdiction, and the principal judicial organ of the United Nations. The judges are appointed by the United Nations. It is not the party who will choose the judges in the ICJ. So, the ICJ, under the Article 38 of the Statute of the Court, the parties have no choice in specifying the rules to be applied in the court because it will follow UN charters but by virtue of the Article 38. The jurisdiction of the court includes all dispute between the states concerning the interpretation of the treaty, any question of international law, but only among the states. The existence of any fact constituting the breach of international obligations and the nature or the extent of the reparation of the be made for the breach of the international obligations among the states or between the states, and such disputes will be resolved by the ICJ. The Charter of the United Nations refers to the arbitration and judicial settlement in the Article 33, Clause 1 of the two methods among the methods of the Pacific settlement that states are encouraged to utilize the seeking the solution to their international disputes. It also provides the Article 36, Clause 3, the guidance to the Security Council requiring it to take into consideration the legal disputes should be in general rule be referred by the parties to the International Court of Justice. Both the way they can have the jurisdiction to entertain the disputes among the state by virtue of the Article 33 Clause 1 and Article 36 Clause 3. Okay. So now, despite the provisions, the Charter does not impose on members of the United Nations the obligation to submit any dispute, even a legal one, to the court. Moreover, the Charter provides nothing in it shall prevent the members of the United Nations from entrusting the solution of their difference to other tribunals by virtue of the agreement already in the existence of which they may be concluded in future. If the United Nations want, they can shift it from the ICJ to any tribunal because that power is already there in the United Nations Security Council and the General Secretary. So they can shift it from the ICJ to the tribunal also. So this way that we have studied today regarding the adjudication of the disputes are concerned. And the next class we will see the institutional methods of dispute settlement. What did you mean by institutional method of dispute settlement, Raymond?
The instrument.
Institutional method of dispute settlement means what? If you know it, you tell me. If you don't know it, say pass on.
The mechanisms.
Yes? Say. Pass on. I want to say.
Pass on.
Pass on. Institutional method means regional institutions and UN institutions and UN delegated organs, UN special organs, or the UN makes any institution and where the dispute settlement would be there. So that is the institutional method of dispute settlement involve the resort to the international organization for the settlement of the international dispute. These methods have come into existence with the creation of the international organizations. The most eminent organization which provide a mechanism for settling the dispute between their member states are the United Nations and the regional organizations such as the European Union for the Europe, Organization of the American States in the Western world, and the Arab League in the Middle East, and the African Union for the African continent. How many are there regional? One is the United Nations. And the
There are
other?
four.
Other?
The others are regional organizations.
Hela, Wangia, Amna data, voice is breaking. One is the big one, United Nations, and the regional organizations are for the European Union. Breaking voice, okay, no, start because breaking voice I am getting. Just unmute it, I will give the answer. In the European Union is there. In the American states, for the Western world, the Organization of the American States. In the Arab world, the Middle East and the petroleum exporting countries are concerned, Arab League is there. And for the African continent, African Union is there. Total 4 regional agencies are there. 1 high command is there, United Nations. That is called the institutional method of dispute settlement. Is it clear? Say yes.
Professor.
Yeah, peaceful settlement of the
Professor.
dispute by the United Nations, we will see tomorrow. Today I would like to stop up to this extent. because in the tomorrow we'll see, I'm keeping the asterisk next class, that peaceful settlement of dispute by the United Nations and four organizations. These four organizations we already studied, but it is a repetition. Am I right?
Yes, sir.
Okay. With this, I will stop my today class and try to be ready for the physical examination. And you said you are going to submit this test, first test on 14th. Am I right?
Yes, Prophet.
Yes, I may be in office or may not be in office. You can give in my house also, or we can make an arrangement for other thing also, provided we agree together in advance. Is it clear?
Yes, Professor.
Yes, with this I would like to wind up my today class. Asante sana na shukuru sana. Mungu akubariki na
जनगणमनाधिनायक जय हे
भारत भाग्य विधाता
पंजाब सिंध गुजरात मराठा
द्राविड उत्कल बंगा
विंध्य हिमाचल यमुना गंगा
उच्छल जलधि तरंग
तव शुभ नाम जागे तब शुभ आशीष मांगे गाहे तव जय गाथा
जनगणमंगलदायक जय हे
भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
सारे जहां से अच्छा हिंदुस्तान हमारा। जय हिंद।
ख्वाब तक सिर्फ कश्मीर की आज़ादी के आते हैं।